Welcome to the course in Civil Procedure. I'm John Drobak, and I'd like to spend a few minutes telling you a little bit about myself and about what I'm going to cover over the next 8 weeks of the semester. I've been teaching civil procedure at Washington University for over 30 years. It's a field that I've spent much time with because I do research. I've written articles and books in the area, and I've taught other courses that build upon the basic course in civil procedure. I've also enjoyed teaching students who are not from the United States. In a number of years, I've taught in Prague, I've taught in Utrecht in the Netherlands, in Lisbon, in Corsica, and I've really enjoyed listening to other students talk about their procedure compared with the United States procedure and getting their perspectives on the ways we're different, and if they like the way we are, or if they think really the United States should really move towards some other kind of procedural system. So I hope that we can talk about things like this during the semester, and I'm looking forward to hearing your views on this. Let me give you a brief summary of 5 things that I want to cover this semester. You have a syllabus, so you know what I'm going to cover in each class, but I want to emphasize 5 things that really, in part, run through the entire syllabus, the material we're going to study. The first is the United States has an adversary system. It's not inquisitorial like a lot of civil law systems. That means the judge plays a very passive role. The parties and the lawyers really make all the decisions in the case. For example, if someone gets hurt, they fall on a banana peel in a grocery store, there's no requirement that they sue. If someone breaks their back or their leg and they don't want to sue, no judge, no government official makes them sue. The parties and the lawyers get to choose the legal strategies they want to use. They get to decide which witnesses, how to put their trial together. It's something that is always left to the parties. The other aspect is the parties can settle anytime they want to. Even if the state has invested years and thousands of dollars into a litigation, if the parties want to settle the case when it's on appeal to the United States Supreme Court, it's their own business. A few years ago, there was a controversial case involving reverse discrimination, where a school district in New Jersey had 2 teachers of equal quality, and they laid off the white teacher because they were looking for a more diverse group of teachers in the school. So the white teacher sued. And at the time, the law was unsettled, so it worked its way through the court system all the way to the United States Supreme Court. And an organization that supported affirmative action paid off the white teacher before the Supreme Court could decide the case, so she would dismiss it because they feared that the Supreme Court would rule in a way that worked against this kind of affirmative action. That's their business. There's nothing wrong with deciding to settle if you want to do that. That's part of the American way. The second aspect is the influence of the Constitution and history on modern litigation strategy. Our Constitution was enacted in 1785, and the United States Supreme Court views it as a legal document. So it's given precise meaning to very vague terms like due process of law. It interprets it like a legal document. The Supreme Court views it as the highest law of the land, so whatever's done in any state or federal court has to meet the standards the Supreme Court says the Constitution establishes. It's a strange system because it's very hard to change our Constitution, so we live with this document that really guides all of us, even though it's over, 200 and 240 years old. The third aspect is the federal nature of the United States. When we beat the British in the Revolutionary War, we were 13 colonies. The 13 colonies became 13 separate sovereigns, each a descendant of the monarchy. Each one viewed itself as a government. And those 13 sovereigns together formed an umbrella government called the federal government. And so 13 became 14. And over time, as more states were added, we now have 51 governments in the United States, the 50 state governments and the federal government. Each one is a sovereign. Each one has aspects of sovereignty, and that influences the relationship between the federal government and the state government, as well as the relationship between federal courts and state courts. And you will see that as we study the procedure over the next few weeks. The next aspect is juries. Nobody in the world uses juries the way we do in civil litigation. Again, it goes back to the historical effect of our Constitution. The 7th Amendment to the Constitution requires the use of jury trials. The wording of the amendment says the right to a jury trial is preserved as at common law. And the Supreme Court has taken the word preserved literally. So we look back to 1785 to see what the English did under their jury system for the common law. That's what we do in America today. Now, it's a strange system because even the British have given up on their juries in civil litigation decades ago. They use juries for criminal cases and for dignity torts like slander and libel. They don't use juries for anything else because most people think that juries are not as good fact finders as judges. But in the United States, because we have to use the jury system, litigators have learned how to have a special form of litigation where they're trying to teach lay people about the law at the same time talking to the judges. So really they're litigating on two levels. The last unique aspect of the American system are class actions. Class actions have been around for a long time, and they're a very important part of modern litigation in the United States because the stakes are high. I mean, there's been classes where there's been over 50 million members in the class. There's been class actions where tens and hundreds of billions of dollars have been awarded to successful classes. And think about this, the lawyers get a percentage of the fee. The ordinary tort lawyer gets 30 to 50% of the fee. This is an impetus for lawyers to bring class actions. So we've developed a system where people fight over whether or not class actions are appropriate in given circumstances, and that's what I'm going to talk about when we come to the class on class actions. A lot of other countries are thinking about adopting our class action system, and I think it's useful to know the really good aspects of the class action, but danger the class action practice can have for society too. So that's the main themes of what I'm going to teach you over the next 8 weeks, and I hope that you can see these running through the specific material that I'll teach you.